Good morning, everyone. Glad that everyone is here for this subcommittee hearing. Subcommittee has held a series of hearings examining the regulatory process. We've determined over the course of these hearings that a robust, efficient process will lead to better regulations and better regulatory outcomes. We haven't had a lot of dissent on that. It's a matter of just working on the process. Today's hearing focuses on the proper role of regulatory enforcement. It goes without saying that writing a law or developing a regulation is easier than actually enforcing it across 50 states and our territories in a fair, predictable, and consistent manner. But doing so is essential. Fair, predictable, consistent regulatory enforcement procedures must be understandable for all stakeholders. I believe that most federal agencies agree that transparency is important and that providing accessible compliance assistance services is essential to any comprehensive enforcement regime. Safety, fairness, fighting discriminations are all great goals of our regulators and of enforcement. I think it's a reasonable thing. But as we've learned from previous hearings, the sheer magnitude of the code of federal regulations means that understanding and complying with regulations is a gargantuan task for most individuals and businesses. The complexity of the regulatory system, coupled with the fear that failure to comply, even if complying is completely accidental, will result in a fine or penalty. That means that a business will feel they're targeted for arbitrary violations that they don't fully understand. As a result, regulated parties often feel confused. They deal with conflicting compliance information, and it leaves them vulnerable to the whims of any regulator. In fact, one small business owner from one of the states mentioned back to us that when faced with the overwhelming number of regulatory requirements, what chances does a business have? Indeed, many individuals and businesses believe that agency officials enforce regulations in an unfair, unpredictable, and arbitrary manner. Because businesses often feel they're targeted arbitrarily, they're understandably fearful at times of federal regulators. I hear stories from businesses that their only interaction with an agency enforcement officials is to inspect and issue fines. As a result, my constituents tell me that their relationship with agencies have deteriorated and that instead of inspectors working with businesses to identify and solve compliance problems, government regulators show up, issue a fine, and punishment. When businesses choose to avoid interaction with federal agencies and dread inspections, our shared regulatory goals are not achieved, and we have a breakdown between the government that is designed to serve people and the people that they serve. Agencies should play an active role in changing this culture. Agency officials, starting at the top, can set the tone by emphasizing compliance assistance, prevention through education, so that finable offenses, not to mention larger tragedies, do not occur in the first place. If businesses are no longer apprehensive in approaching an agency when they need clarification, they will likely find regulatory compliance easier, and it will be more successful in meeting compliance goals. In turn, all of us will enjoy safer workplaces and a cleaner environment. I look forward to today to discussing our shared goals and feasible solutions. It's my hope we can start setting a tone in all of our agencies that helps engage with people and helps the people that are designed to serve the nation and the people that we serve to actually have a better relationship in the days ahead. With that, I'd recognize Ranking Member Senator Heitkamp for her opening remarks.
Thank you, Chairman Lankford.
Let me just give you a couple quotes. As we ask the question and we let people know that we would have this hearing, we're trying to gather information and background source, and I've got several stories and things that I can share on it. Let me just pull a couple quotes here, just about the fines and the mindset of when inspectors come. One person told us that they were told that when an inspector came, they said to them, if it takes all day, we will stay until we find a violation. One person said the EPA views businesses as an ATM to be fined regardless of the determinations of an investigation. Another one said the determination of whether there's a fine and the amount depended on the mood of the investigator. Said this one, there's been a culture change from one of compliance assistance to one of scaring people into compliance. And then this one, more stick than carrot. That was interesting. Now, I would tell you, just interacting with the two of you and hearing your mindset and your view on this, I think if most business folks were sitting across the table from you and talking back and forth, they could work a lot of things out. But there is a real sense in what Senator Heitkamp had mentioned before. I've heard from numerous employers saying, if I went back, and people that own small businesses, if I went back 10 years ago, when someone showed up for an inspection, they were extremely helpful to me, and they were helping me find safety issues. Now they show up and there's just a fine. And something seems to have shifted. And now it's gone from, I'm grateful to have the help to walk around the facility with fresh eyes to, oh no, they're coming, I'm going to have to pay a fine for something, no matter what it is. So I don't know that you could say what has occurred, but that real life sense is out there. And so this perception that for many is reality of I don't want an inspector to come help me find safety violations because I know I'm going to have a fine, even if it costs them all day to stay here. They're going to find something. Some of this goes back to the training y'all talked about before. I know EPA had the wonderful experience of several years ago having someone in Region 6 say, the way we do this is like the Turks used to do it, to go into town and grab 5 guys and crucify them, then there's no problems after that. Obviously, that's not the EPA's attitude as a whole. And when you talk about trying to train people in regions and making sure it's consistent, that comes to mind immediately when you think there was a region that was most certainly not consistent with the EPA national value. My question, I'm actually going to get to one. My question is, how do you balance out the issue of compliance and the real deterrence that a fine is, and being helpful to someone and being able to walk through? We want any business to have a fresh set of eyes to look around for health and safety issues. We don't want them to be able to push us away. How are we currently trying to balance that out to re-engage with business to say we want to be able to help in the process? And I'll have just both of you mention that.
Thank you. First, I would like to address the disconnect that you have described. Clearly, that's what it is. I hope, certainly from EPA's perspective, we really believe in our mission to reduce pollution and protect the health of the communities that we all serve. That really is the mission. That's how we feel about it. I understand that there is a perception out there, as you've well described, and so we need to work at getting around that disconnect. I believe there are a couple ways that we've tried. We do have compliance assistance available for small businesses. We've tried to improve on that and making it available. We've also focused some of our penalty and enforcement methods to look at ways to deal with small entities with small violations. We've expanded our we call them ESAs, expedited settlement agreements. These are ways that we can, when there is a small violation seen in the field, we can address it rather quickly. We use this for things like underground storage tanks where there might be a leak, some record keeping in some of our chemical violations, things that we see that are small, can be remedied quickly. We try to have what is really a non-negotiable agreement. It's small. These are the facts. We can all agree to them quickly. And we've tried to expand our use of those so that when there is a small violation that can be dealt with quickly, we can use that.
Can you walk me through the settlement process? And this will be one, Mr. Barab, I want to get a chance to visit with as well. Y'all both mentioned the settlement. There's a very clear process. And as Senator Ernst had mentioned before, I get it as far as the benefit and the cost and the risks and all those things. I get the process and going into that.
Sure.
The challenge is once you go through that, you set on a fine, and then there's a process to have a conversation on settlement. Here's the fine. Now let's talk about if we're going to settle on it. How does that part of the process work? What's the mechanics of that?
Okay. Let me start maybe a little earlier. It really is an incremental process. An inspector goes out and sees that there's a problem.
Right.
Unless it is an emergency that needs to be addressed immediately, there is usually a discussion about it, and then they come back to the office and discuss what, if anything, needs to be done about it from an enforcement perspective. After that determination is, if there is a violation that actually merits taking enforcement action, then there is a discussion about what level of enforcement to take. Is this something that can be dealt with administratively by going back and talking about it and seeing whether it's a small, quick resolution, or whether it's something that's going to require changes at the facility that would require some investment and some monitoring? An awful lot of them don't, but if they do, there's a further discussion about that.
Can I ask a quick question on that? When you find a violation, does that warrant a fine every time?
It depends.
As far as, do you feel an obligation coming out either legislatively or from a guidance that if there is a violation, that's a fine.
We have enforcement discretion, and we
Okay.
can't.
Mr. Barrett, do you all have enforcement discretion as well? Do you feel that?
I'd say generally we're required to issue a fine of some sort when we find
Every
a
time.
violation. There is some discretion there, but yeah, that's the
Okay,
general.
I want to talk about that. I hate to interrupt you, but I want to get some clarity on that to make sure we're heading the same direction. Go ahead and you can finish, Mr. Shingman.
So there is enforcement discretion. We decide whether it is something that within our policies merits further action. That further action may be an administrative order or agreement that we talk about. We reach agreement that this is, the first thing we want to do is abate whatever the problem is. And so that's what's addressed first, whether it's going to require additional action, stopping something, starting something, try to resolve it that way. If we reach that resolution, in most cases, there will be at least some penalty because there was noncompliance. And then we go through the factors to decide how large the penalty is. In a bigger case, what would happen generally is there'd be further discussions, and there may even be a referral to the Department of Justice, and then there's further discussions within EPA, with the Department of Justice, and with the entity that is out of compliance. So it's an incremental process, and iterative. I think a lot of the things that you're hearing about tend to be the small ones, but the reality is there is usually a process, and there's a lot of dialogue back and forth before there is an ultimate resolution about what injunctive relief or change needs to be made in the processes to make sure that the company is in compliance going forward, what mitigation needs to be done for any damage that might have, like a spill or something like that, if it needs to be cleaned up, and then what penalty do we need under the standards that we have.
We're still back to the settlement thing. The process I get there. Once the fine has been turned, the settlement that you're describing, is that typically a judicial settlement? We're in a court and we're trying to work through that?
It could
or
be both.
What's the other settlement?
The other is administrative, in which case we would have either an order that is appealable or a signed agreement, and that goes through our administrative process to the Environmental Appeals Board.
And that is a more fluid conversation that's
Yes, it
happening
is.
across the table. We agree on the facts, know what's a reasonable fine, and you're discussing that process.
We certainly try to reach agreement on all of those. Obviously, we don't always.
Mr. Barab, is the settlement process pretty similar for y'all? At the end, I understand once you get to the spot of a fine and an assignment, you had mentioned very well about the exact numbers and the changes that have happened in the Budget Act and such from there, but I'm talking about the settlement process at the end.
Yeah, our process is slightly different than EPA's. Once we finish the inspection, the inspector then goes back to the office. The area director actually has authority over what the penalty will be, assuming any kind of violations have been found. At that point, the employer has 15 days to contest the citation if the employer wants to do that. During that 15-day period, there's a chance, and we strongly encourage employers to engage in what we call our informal settlement process. So the employer comes into the office, the area office, and sits down with our area director, and they try to work out some kind of settlement if possible. And again, looking at the violations there were, looking at the employer's defenses, looking at the violations, looking at the abatement period. All of those things are discussed during that informal period. And again, in about 2/3 of the cases that we have, we do reach some kind of settlement at that point with the employer. Now, if no settlement is reached, then within that 15-day period, the employer can legally contest the citation. That then goes to the Occupational Safety and Health Review Commission. There are administrative law judges that decide that, and that case then moves up that ladder.
Okay, let me ask the question about the flexibility that you have or don't have on fines. And it's my understanding that is it a guidance or is it statutory that if you see a violation, there has to be a fine?
That's statutory, but our maximum penalties are set also by law.
But as far as a minimum penalty, that is statutory, that requires?
The only place there's a minimum penalty is with willful violations, and that's a $5,000 minimum, $70,000 maximum. And as I mentioned, there are also, by statute, we also have to consider, as EPA does, size, history, and good faith. So there are almost always reductions.
Right. So at the end of this, as y'all both mentioned, that the goal of the penalty is always deterrence, and I get that. But the goal of the regulation and of the statute is usually health and safety and environmental protection and such. And the fine, the penalty here becomes a vehicle to help accomplish some of that. But I don't know of anyone that's written a statute to make sure that we find some entity as well. That's the worst case scenario for us. Give you the easy example we've all experienced. My daughter, when she was in high school, was pulled over by a police officer because her dad, me, wasn't helping her watch for things like a headlight that was out. Now, she's also a teenager and she can watch for that herself. But as the dad and a 16-year-old gets pulled over with a headlight out, she was given a warning by the police officer and said, hey, did you know? She said, I didn't know, didn't catch it. He gave her a warning. We got back home and spent $125 rearranging the front of her car to do a new headlight. Joy, okay? She got a warning. We fixed it. The health and safety issue of getting both headlights working was accomplished. What I'm trying to figure out is how much flexibility do your compliance folks have to be able to walk in and say, you know what, that trash can's in the wrong spot, and someone to say, I didn't realize. When I walk through manufacturing locations, as y'all do all the time as well, on the wall somewhere, there is a library of 4-inch plastic binders that are sitting up there with all the regs and all the requirements that are sitting there. And most of the people that run the manufacturing locations live in dread that they've missed a page somewhere from those 6 4-inch binders that are up on the wall somewhere, trying to make sure that they miss it. How much flexibility do you feel like you have to be able to help people to say, you missed one? And it's not necessarily a fine, and it's not necessarily, you know, a leak that's going to damage a lot of folks, or wasn't necessarily health and safety, but they missed one.
There are certainly small things that we correct as we walk around, or ask the employers to correct. That there's no doubt about that. But again, our concern is saving lives. And
sure.
Our serious violation, which is only the maximum of $7,000, there's a requirement there that the way a serious violation is defined is that it has to be likely to cause death or serious physical harm. So those are again fairly serious as the term is when we find those. And
I have no issue with that. I'm talking about minor fines.
Yeah.
One of my manufacturers was fined because he had a shelf in his workspace for one of his workers that was 6 inches too low. No, I don't know all the story on that, but I stood on the floor with him and I said, that shelf right there? And he said, yep, that shelf right there we had to raise by 6 inches and we got a fine for it.
Yeah, we generally, I mean, we hear stories like that, and generally when we look into them, usually there's something else accompanying that with it that's of a more serious nature. But, you know, when we have situations like that, we're always happy to look into them, but it sounds unlikely that there would be any kind of
But I think what
fines.
we're asking is, let's say you see an extension cord that's located in a location where somebody could trip, that's obviously a hazard, you note it. Are you telling me because that's a violation, you have to assess a fine?
We also have various means. We have other than serious fines where they can be very low. We have a quick fix where we can, if the employer fixes it right away, we can either minimize or in some cases eliminate the fine. So
Yeah, that right there, stop.
okay.
You said eliminate the fine. So you do have discretion to not impose any fine.
In
based on-
exceptional cases, in general, our law requires us to issue a fine when we find a violation, especially if it's a serious violation. But there are other than serious violations. Now, an extension cord, I mean, that is something that can cause fires,
I know.
electrocutions. It's not necessarily, I mean, people throw some things out, but they actually, when you look at them, when we look at the past history.
No, I thought it was a good example because it can be, in the wrong place, incredibly dangerous. But my point is, I would have to go back and take a look because I am shocked that you could not waive a fine or a penalty in its entirety, given kind of the relationship and compliance and what did they know and lack of knowledge and severity. So we'll follow up. I've got to go vote and go to banking. So
Thank you. We'll finish up in just a couple of minutes because I'm going to have to go follow and vote as well. This is one of the areas that we want to examine. It's the reason we have this type of hearing, to be able to dig into it and find out from y'all what you need, because I would hope that you're in the same position that we're working on health and safety and making sure we're protecting lives. And this is not all about fines. As you mentioned before, the fines are not coming back to the entity themselves anyway. So this is not a quote-unquote moneymaker for the agency. It is a deterrent. But we've got to find a way to be able to balance this out. One of the things that I had noticed was in 2011, the President issued a memorandum for the heads of the executive departments on regulatory compliance. OSHA and EPA were specifically noted in that for being good actors in it, and highlighted some of the compliance enforcement information and how you're making that publicly available. So that's a positive thing to say. Your agencies both are building in transparency on the basic issue of compliance enforcement information. Not every agency is dealing with this. I'm not going to ask you to answer for everyone else, but the Department of Transportation updated their stuff in 2011, and then since 2012, there's been no change at all on their website on the information on compliance and enforcement information. So one of the things that we're asking of the administration is to help us when the information gets out there and is helpful, to make sure all agencies are actually fulfilling that, or getting that information out, which both of your agencies are, but Department of Transportation is not. So that kind of consistency is extremely important. We do need to work with your entities on things like minor violations. Was a poster missing? Was a piece of paperwork missing? Again, I had another agency and another entity that I dealt with as a manufacturer in my state that had not turned in paperwork a particular year, saying they had nothing to turn in. And their wrong assumption was I had nothing to report, and so I didn't have to turn in that report this year because there was nothing to report. They ended up having a huge fine come down on them for not turning in paperwork saying they had nothing to turn in. Well, again, that just begs this question of how is that helping health and safety? That's a paperwork violation issue. There should be a, hey, you didn't turn that in. You're right, we didn't turn it in. But instead, they had a fairly significant fine that came down on them for that. That's the kind of stuff that we need to figure out. To say, if you feel bound, or if agencies feel bound to be able to do a fine in that type of situation, then we have a problem. One of our businesses said that they were hesitant, and this was specifically on OSHA, was hesitant to voluntarily invite OSHA into the workplace to do the on-site consultation programs because of their concern over that. Now, I heard from both of you, you want to work with especially small businesses to do the on-site consultation to be able to help them through that. What is something that can be done to encourage more businesses to say, invite us to come in, we're not coming in to fine you, we're coming in to be able to help, to do almost a pre-inspection inspection?
Yeah, I often call our consultation program our best-kept secret. It is a wonderful program. We try everything we can to really promote it, not only ourselves, but through associations. And I want to emphasize, and we try to emphasize this with employers, we fund at least 90% of the consultation program. We don't run it, though. We give that money to the states, and they run it. So it's totally separate from OSHA, and that's what we try to emphasize to employers, that this is totally separate from OSHA. It's a free visit, basically, that small employers can receive, and everybody should be taking advantage of it.
But some are concerned that they shouldn't because they're, for whatever reason. What I'm telling you is, it's a good program, and it does focus on health and safety and on compliance on issues and thinking outside the box on some things. There has to be a way to be able to communicate this so that individuals know, hey, this is a neutral spot. Unless there's some major gross something that's here, this is a good spot.
Well, we'd love to work with you on ways to do that. There are a lot of myths out there that we would love to be able to combat, and we'd love to work with you to do that.
This one's not necessarily, this is something I'm saying, a perception of reality. This is a business owner that said it to me directly. Yes, I know there's that type of consultation. There's no way I would take that. Sure.
And I would just briefly like to say, particularly for small businesses, we have an audit policy where if they voluntarily disclose and fix what it is, there's minimal, if any, penalty at all. So we encourage it. The sooner it's disclosed, the more voluntary audit of themselves to determine what the problems are.
Is that the e-disclosure
Yes,
program? Okay, tell me a little bit about how that works, and what I'd like to know is how do you evaluate its effectiveness on how it's actually accomplishing the mission? How do you evaluate that?
Well, it's about 2 months old, so I'm not too sure.
Okay, it's a little early then, yeah.
I don't think we can give you any kind of an evaluation, but it was formed so that we could quickly see these audit disclosures for a number of cases, particularly smaller ones like you've described, and for small businesses where they, through a web portal, give us notice of what what they are disclosing.
So give me an example of some of this, because this is their own safety systems, right? Their own safety checks that they're doing. They find something, know it's a violation. Give me an example of something they would turn in and say, hey, we found something, we're going to report it.
We've determined that we don't have the number of containers that we are supposed to for a certain thing, or they aren't, they haven't been updated at a certain time. So we are going to do that. We discovered it at X date. We did whatever it is to remedy it. It will be done by Y date. And we are disclosing it to you now, and we have a policy for making sure that it's not going to happen again. And this is all disclosed electronically, and if all of the criteria are met, they will receive a notice that that it's been disclosed and the issue would be closed out.
And including the benefit penalty, as you mentioned before, part of the penalty is did they receive some sort of benefit by delaying that? Would that be waived as well, or would that be something you have to look at and go, hey, you didn't change this, you got an arbitrary benefit that other companies didn't get?
I think that wouldn't apply here because part of the criteria is the early disclosure. So
Okay.
the criteria themselves eliminate those problems.
Okay, that'll be one that we want to watch to be able to see how that works, because that gives a clear set of guidelines out there that people can find and note and to be able to help self-manage. And I just want you to know from our committee, we're going to watch and figure out how that's being evaluated to see if that's something that can be shared with other agencies and entities. I would also share as well, and this is just in our ongoing conversation about fees and fines and penalties, we're watching some entities like Fish and Wildlife Service. Fish and Wildlife Service has the opportunity for a penalty or to be able to make a contribution to a third-party organization. That's a nonprofit. We're trying to figure out who sets that, who guides that, where does that money go? That is money that would have been to the general treasury. Now that is to a certain outside third-party entity for mitigation or whatever purpose is. And so we're asking, I think, a fair question for the taxpayers' behalf. If it's a fine that goes to the general treasury or that you donate to a third-party organization, we want to know who picks that and where does that go and what's the long-term benefit of that. EPA uses a supplemental environmental projects. But my understanding is that is you can have a penalty or you can basically fix it, and here's what we would encourage you to do in some ways. How are those SEPs decided?
Those SEPs are voluntary by the company if they to set off part of the penalty by doing a project. Let me make it clear that they are never cash donations.
Right.
They are always voluntary projects to help the environment. There needs to be a nexus between what that project is and what the violation was. There will also always be some cash penalty. It isn't 100% mitigation against the penalty.
Is it typically 80%? Is it because the goal again is to deal with health and safety and environment at that point? So you're saying it could be a control project or a monitoring project or something else around them or around the city, around the community? What does it typically look like?
Typically, it looks like something like a decision to do monitoring for children for asthma or for lead in a certain school district for a certain period of time. The asthma might be the result of a clean air violation. The lead for a different kind of the lead monitoring, those sorts of things, purchase of emergency equipment, if there's been a violation that's similar to that. So there's a policy. We've redone our entire policy so that it's much clearer. We did that last year, so the standards that are necessary to meet, we have strict standards, and they're more clearly set out. A small business can get up to 100% set off of their penalty. Others, usually it's around 80%. It really depends on the quality and the type of the project, but it is never money that is just handed to somebody. It is never a project that EPA itself controls.
Right. EPA is different than other entities on that. There are other entities that are doing mitigation separately to an outside third party rather than a fee or fine, and that's one of the questions we'll ask. Obviously, I'm not going to ask you to answer for another entity on that. We are quickly running out of time, and I know you're thoroughly enjoying this conversation, but we do have votes that are happening currently, and I'm going to have to head over to that. I'm not going to hold you over to be able to come back and forth. I do want to maintain this conversation. What we would ask of you is I'm sure that there are ideas that you or your entities would be interested to be able to share of ways that can improve this process, whether that be process changes, issues in statute that have become a problem, or that create a barrier between the people we serve and those of us who serve them, as you do as well, that should be fixed and could be fixed. I want you to know those are the type of things we're also looking for as well. This is not a one-way conversation. And for this committee, we hope to be able to put products out in the days ahead to say, let's help fix some of the broken relationships that we have there and still be able to work on health and safety and environmental protection that need to be done. So as you have thoughts on that, we're free to hear those, and we're interested in those as well. I appreciate you being here and for the work that you put into this conversation, and we'll do some follow-up and some questions for the record in the days ahead on that. I would make a statement to all of us on February the 24th, this subcommittee will also hold a hearing examining the burden of federal statutes and regulations placed on state and local governments, what we have learned since the passage of the Unfunded Mandates Reform Act of 1995, and how the Unfunded Mandates Information and Transparency Act can improve upon those efforts. This will conclude today's hearing. The hearing record will remain open for 15 days until the close of business on February the 26th for the submission of statements or questions for the record. With that, thank you very much for our witnesses. This hearing is adjourned.